Thank you.
Thank you, friends, for joining us today for this little webinar organized by Continental and Asper here for all your benefit and to understand about inheritance planning. So I'll just quickly run through a little presentation with slides and talk you through. And once that is done, then we are all ready to take through your questions. Just to go through a little introduction about Goodwins. Goodwins is a 22-year-old law firm, originally started in Singapore, and we are 24 members with 15 lawyers in the UAE. We are what we call a boutique law firm, and with more than 180 years of legal practice all put together. And we are spread out in Singapore, UAE, and India. And we are part of a larger group called First Law International, which consists of almost 16,000 lawyers around the world. That's about Goodwins. And now going into the topic of inheritance planning. So let's run it through why inheritance planning is important. So I'll give you some illustrative examples, life examples, which we have dealt with in the recent past. Of course, we do deal with these things day in, day out, but this is all some recent cases. Where here, a lady goes for a cosmetic surgery to India, a minor cosmetic surgery, and it leads to complication and she passes away, unfortunately, leaving behind a husband and 2 young sons. So now what happens? All the bank accounts, which is joint as well, along with the husband, gets frozen, and all the expenses are maintained in those accounts, so nothing can be operated with that. And money has to be brought from elsewhere to keep the family going. And also she was working for a bank, so because of that, the bank has, because she had loans and mortgage loans, etc., with the bank, and the bank had frozen her accounts and recovered her end of service benefit towards whatever she owed the bank. And the most importantly, the elder son was going for higher education, and that came to a standstill because all this money was stuck with the banks, unable for the husband to operate. And looking at another type of a case, of course, this is a working people, but the other type of case is a story of a businessman where the husband passes away, the wife and 2 young children are left behind. Now, what happens is that he owns a business with 100% employees. Everything comes to a standstill because he was the sole owner for the business and he was a signatory in the bank, etc. And ultimately, the wife got 1/8 of what the husband owned, and rest of it went to her in-laws, to her father-in-law's control, and 2 young children and their control, guardianship, as well as the assets, their share. So almost 7/8 of the assets went to the control of the father-in-law, and that is all hell broken with all the disputes between the father-in-law and the daughter-in-law, and business gets into a little serious trouble because they are unable to continue with the business. So these are a couple of stories which I wanted to share. What happens when we don't do inheritance planning? So why inheritance planning? Of course, most importantly, to appoint guardians of your choice. As a parent, I always think that your children are your biggest assets, and you have to have that sorted out. Your children have to be sorted out. So to appoint guardians of your choice, God forbid if both parents are gone. So somebody else is there to appoint it to take care of the children. And of course, to legally provide for people of your choice whom you want to give as such. And also to avoid any legal complexities and to have that emergency money, which is very, very important. Because we come across a lot of cases where people don't have enough money. They have enough money in bank accounts and in assets and investments, but they don't have money for the emergency to handle it then and there. And of course, to decide the mode of distribution, how to be distributed, when to be distributed, and the most importantly, as far as UAE is concerned, to remove the freeze on the assets on a fast track. Because as you know, when a person passes away in the UAE, your bank accounts and everything gets frozen. from further transaction. Cars cannot be transferred, bank accounts cannot be operated, assets cannot be given for rent. Various things happened in this situation. And coming to those of you who are interested in business or who have businesses or who own businesses, which is very important, is organizing the succession of the business so that there is no legal complexities and the business continues successfully and you encash the goodwill of the business. And what happens when a business owner passes away? There are people who are ready to come and collect the money which they have to collect from the business. But people who owe money to the business don't come anywhere near the scene because they vanish in thin air. So unless there is a proper succession and proper records kept of a business, you will not be able to continue the business in a successful manner. And most importantly, what happens is that for the continuation of business and so that the business can be given properly to the legal heirs, and if it has to be wound up, the end of service benefits and salaries, pending salaries, everything of the staff is paid out. So that is one very important thing of business succession planning. And going further, talking about the law, of course, being a lawyer, I need to tell you about the law, what happens in this part of the world. So it is Federal Law number 5 of 1985, which is actually the civil transaction law of the UAE. A couple of articles deals with inheritance. One is Article 17, the other one is Article 18, where Article 17 allows the UAE law allows for you to apply your own country's law. The respective law of your country can be applicable for a foreign national, for an expatriate in this part of the world, as far as inheritance is concerned, not for anything else. It's a personal law, what we call as. For personal law, it can be applicable. So that is what this Article 17 says. Article 18 says that for the real estates or the fixed assets here, the local law also will apply. That doesn't mean local law will apply for inheritance. If the local law will apply for the transaction of that asset, because you need to pay certain fees and taxes when you have to transfer money to the next generation or the legal heirs. Now, coming to what comes under personal law or what comes under services on personal or inheritance law. This is a separate area of practice compared to anything else. Of course, as a law firm, we do everything, but then this is a particular thing which has separate court of law in this country. This country has a separate court of law for this particular purposes. And what happens is that UAE is a country which follows the civil law system. That is the French legal. It's basically a French legal system which they follow in the UAE, which we call the civil law for everything, except for inheritance, personal and family, where they apply the principles of Sharia. So Sharia gets applied to this area of activity. So in that, to the circumvent issues so that you can apply your own country's law, you have various things happening. You can prepare wills, you can prepare affidavit, GPOAs, and you can do a business succession planning in your business. You can do inheritance and retirement tax planning, because some of you may come from inheritance tax countries, or some of you may come from countries where there is no inheritance tax, but you may own assets in countries where there is inheritance tax. And when you go further, of course, in certain business organizations, we need to organize trusts or foundations or offshore companies to organize their inheritance based on what nationality, what religion, what background they come from, and what is the portfolio of assets. And most importantly, of course, it takes care of family disputes, settlements, and child custody, and also the interstate probates and execution of wills. So what happens is that when a person has will, when a person passes away, that will has to be executed. We call it the probate process. It has to be given to the court, and it has to be validated, and then only the banks or the RTA or the land department will accept that as a document. So that is a process which we call as a probate process. And when a person dies without a will, we call it the interstate probate, where it's an interstate succession where they don't have any documents in place. So obviously de facto Sharia will apply, and it will go as per the Sharia table. So this is what happens with personal law. Now there is a confusion between everybody about this will and GPOA. In fact, I had a client talking to me this morning also. And he said, "See, I have to have a will in place, but I have to have a GPOA." I said, "For what you have to have?" He says, "No, I have to give instructions to my wife in the GPOA so that she can apply the will." No, it doesn't. These are two absolutely different documents for different purposes. So what happens is that a power of attorney takes care, uh, when you're alive, when you are unable or you are disabled or you're traveling, you're stuck elsewhere, then this power of attorney comes to an effect. And the person whom you have given, maybe a family member, can use this power of attorney to um, manage your assets, but it doesn't replace a will, and it expires when a person expires. When a person passes away, the power of attorney comes to an end, and of course it can be revoked anytime by the person who has signed it. But when it comes to a will, it comes into existence only after when a person passes away, and it lays down what the person wishes and what he wants to do, how to do, what to do with his assets. And it can be amended with a codicil, what we call as an attachment to a will, or if it is a very large change, the will itself can be changed. But these two are two different things, and never mix it and match it between them. They are meant for two different purposes. So this is what I want to present to you as a short presentation, where we give you a little insight into what is inheritance planning and what is succession planning, sharing a couple of stories to it. And now, leaving that aside, I'm all ready for questions, so we can spend the next half an hour or so to address your questions. There is a question and answer bar below, which you will find below your screen, at the bottom of your screen, so you can write it in so that Asfar can take up the questions.
Dave, first question is there's from a client. So the
Yeah.
client says like this: I have a mortgage for a villa I bought in Dubai.
Okay.
How can I ensure that it will be inherited to my two kids?
Hmm.
We are Muslims, and my husband and I have she have 50-50 share.
Okay.
So her question is: in case my husband deceases, what happens with our property? Considering we have 50-50 share, and the vice versa if she deceases, will it go
Yes.
directly to the surviving husband or wife even without a will? Or in case both my husband and I she deceases, will our property go directly to our kids even without a will?
Uh, Interesting question, and a very good question. That is what the case studies which I was sharing. It'll not. It'll not go to. That is the concept of it going automatically to the husband and wife. You will find in countries like the United Kingdom, where we call it the tenancy in common. So it automatically goes to the other spouse. That sort of a system doesn't exist in UAE. If husband and wife own equally, that means 50% is husband's, 50% is wife's. So if one of the spouse passes away, what happens is that the other spouses, the share will remain the same, 50%. So if the husband passes away, the wife's 50% is wife's. Nobody can touch it. But the husband's 50% will go as per Sharia table if you don't have a will in place, or if you don't have any inheritance documents in place based on your nationality and religion. So if you have proper documents giving the other 50% to the wife, yes, it can work. But if you don't have any documents where it gives the other 50% to the wife, then the wife cannot inherit. It will go as per the Sharia table. 1/6 will go to the father of the deceased, 1/6 will go to the mother of the deceased, 1/8 will go to the wife, and the rest of it will go to the children. Boys will get double of what the girls get. Vice versa, if the wife passes away, 1/6 will go to the wife's father, 1/6 will go to the wife's mother, and 1/4 will go to the husband, and rest of it, what we call as the residue estate, as per Sharia, will go to the children. The boys will get double of what the girls get. So this is how it will go if you don't have any documents in place.
One more question added to that, Dev. Now, in this case, the client is a Muslim.
Yeah.
So what is the law like as per the Sharia? Like they can do a
Yes.
will or
No, they cannot write a local will, but there are ways to do things based on their nationality.
okay.
So based on their nationality, we can do things. And if the portfolio, what they own is very large, then there are other ways to move it to different jurisdictions so that it can be smoothly passed over to the next beneficiary. There are ways out.
Oh,
There are ways out to pass it to the next
okay. Fair enough. Now, many of my clients ask this question, like, they are not having any fixed assets like in a property or something like that, but they do have bank accounts and, like in car or, something like that. Do they still require a will, or what will be the answer for?
Definitely. When people buy assets, they become worried about it because it's a large amount of money they have invested. But what they don't think of it is there are a few things like bank accounts. You always own cars. Even personally, I don't own any assets in UAE, but I do have business shares. I do have cars. I do have bank accounts. And many people, if they're employed, they have end of service benefit, which can be a substantial amount of money. Currently, in this challenging scenario, we have cases coming to us on almost on a daily basis. It's very disturbing, but then almost on a daily basis, I have people calling, inquiring about how to do the probate of a, will, or how to do an interstate probate. So now, in many cases, you will find is that they have worked for some organization for a long time, and their end of service benefit is not being paid because the organization wants them to come up with an inheritance certificate.
Okay.
Without getting an inheritance certificate from the court, the organization is not ready to pay. For the basic reason, one is, of course, if it is a government or semi-government organization, it's a mandatory law in UAE that the money has to be paid into the bank account, or it has to be paid to the Sharia court, which they colloquially call. And now we call it the personal status court, court of personal status. They have to pay into that. And then you have to claim the money from the court with an heirship certificate. So even if you own a car, a simple car, it is very important because, uh, I mean, if you're on a decent salary in this country, simple car means at least about 100,000 dirhams or 80,000 dirhams worth car. So that's a substantial amount of money. I mean, like, you don't want to just leave it aside, leave the car and the key here and leave the country. The family cannot just do that, isn't it? They need to sell that car, and they cannot even renew the car without an inheritance process done.
Okay. Uh, One question which comes to in most of the clients is that how long, if something happens to the client, I mean, if something happens, God
Mhm.
forbid, what happens the next process? Like how long it takes, for the bank accounts, we know that it will be frozen, the bank account gets frozen and
Yeah.
things like that. But what is the procedure actually for their understanding?
Yeah, see, the procedure is that we have to, if you have a will document in place, we have to submit that in the court and get a stamped order from the court saying that as per the will, so and so is the legal heir.
Okay,
Okay. And with that document, we open a file and then we get an order to the bank to release the bank account.
perfect.
Now, the other question which has come up is that how much time does it take? It depends on the person's portfolio and the person's asset level and where the person has passed away.
Mhm.
That is also very important because the fastest we have done is about 16 days. We have released the whole thing in 16 days. That is the fastest, of course, very positive thing. But then what happens is that in that case, the person, the deceased passed away in UAE. So it was a local death certificate which was there, and the family was here. So we could immediately file it and get the order to the bank. But when it comes to when the family is not here or the person has passed away abroad, like, see, we recently had a client who has passed away in Quebec, in Montreal, and the death certificate is issued in French. So now we have to transfer this death certificate. We have to get this document attested by the UAE embassy in Canada. And then it has to come here for further process because without the death certificate, we cannot go anywhere with this whole process. I mean, we had to first prove that the person is dead and gone.
Okay.
It's a basic situation. So that itself took about more than a month's time, 1.5 months time to get this whole certificate organized, because he had gone to visit a family member there, and then he has passed away there. Then the family has to sort it out, the whole documentation. So by the time the death certificate itself got sorted out, it took about a 1.5 months time. So it's not the legal process which takes time, but it's the documentation which is required.
Documentation.
So it all depends on various aspects. But the fastest we have done is 16 days. And the longest without any documentation, a mishapped businessman's death, I have seen the longest is 9 years.
9 years. Okay. That tells the
Because we
story.
have proper documents, nothing, and it was all a messy estate left behind by a businessman. So.
Okay. What happens if there is no will? Like you told, now it takes very long time.
Yeah.
Example, now if a client doesn't have a will and he passed away, what happens? Like, how long it will take?
Again, that all depends where he passed away, what is the family lies, where the family is. If the whole family is in UAE, then it's easier to organize all the documentation.
Okay.
But if the family is not here, the family is abroad, or some of the children are abroad, then we have to get affidavits all signed by them.
Okay.
See, recently we had a client who passed away without any will. The mother, the wife, and the son were here. Son is a minor. So that leads to again a complication when you have a minor children.
Okay.
So that again prolongs things. And then what happened? The one daughter was in the United States of America, and it costs us to attest affidavit and document. It costs us about $1,000.
Okay.
To get the whole documentation done just in the US.
Okay.
To get it attested. And so we have to get this document done. Now, the other challenge was this daughter said, I have no time to do this thing, because she's a student in a university doing her master's, and she said, I have no time. So finally, what happened is that this widow had to fly all the way to California, take her daughter, get the whole document notarized, and get it all attested and bring it back. So that itself costed us somewhere around 10 to 15,000 dirhams.
Only for
just
that.
to go and do and come. And in the current scenario, I don't know when we can do that.
Yeah. Okay.
This was about 6 months back, so she was lucky to go and come back. In the current scenario, we have no.
In current scenario, it is impossible even to travel also.
Yeah. So, I mean, like if the daughter says, I don't have time to do it, you don't have. And again, she may be in a lockdown situation. So.
Absolutely. Now for the attendees, if you have questions, please get in this chat icon. You can post your questions here, so that Dev is there for another 3 to 5 minutes, so you can get the answers right from him. So I request you to, if you have any more questions, you can ask Dev directly.
I have one attendee who has raised his hand.
Okay.
Can you check on that?
Yeah. Okay. I have allowed him to talk if.
Yes, Mr. Nand, please. Mr. Naeem? Okay.
No, I am attending another call. I will call you back. I will come back to you. Okay.
We have another question as well.
Yeah, we have another question coming from Vinod. What is the most cost-effective will in UAE?
Oh yeah, always that is an important question which everybody asks. In UAE, to write a will, you have three options. One is Abu Dhabi, the other one is Dubai, and the third one is DIFC. It depends on your nationality. You have to be advised on where it is ideal to do it. But from your name, I do presume you may be Indian. So what happens for an Indian? The cheapest way to sign a will is Abu Dhabi. Abu Dhabi is the most cost effective. Plus, another reason as a law firm we recommend Abu Dhabi is that when it comes to the probate process, Abu Dhabi is the fastest compared to Dubai and DIFC. Abu Dhabi is the fastest way to probate the document, because the judicial system there is pretty, what do you call, pretty efficient, and they have gone ahead of times, and they have set up a very, very smooth inheritance system in the Abu Dhabi Judicial Department. So cost-wise as well as the procedure-wise, Abu Dhabi seems to be very attractive.
Okay.
Yeah.
I'm just giving the permission to speak for everybody so that they can pose the, they can ask the questions.
Yeah, we have some more questions on it.
Yeah. So we have more questions coming in.
Yes, asked another question about the effectiveness of this will in India. Yes, you can apply the same will in India, but when it comes to Indian nationals, we normally prepare separate documents for India, which you can sign it here itself. You sign it in the UAE itself, so that it's easier when the probate comes, you have a separate document for UAE and separate document for India. But you don't have to go to India and do all those works there. You can do it in UAE itself. It is pretty easy and straightforward.
Okay. I think we have any more questions. So this answer we have done. This we have done. Any more questions, attendees? Okay. I think we can wind it off.
I think they have understood.
There is a question from Mr. Musa on the chat box, sir.
Okay.
He says, I have a villa in Dubai, so can I name the will on my newborn son? Yes, why not? You can, when you make a will, you can make it to anybody you prefer. It doesn't have to be a particular person. Only when you don't have a document in place, then it'll be decided by the court, and the judge will decide how it has to go. Based, of course, in UAE, of course, they follow de facto Sharia, and they follow a particular table called Hanafi table, where in other parts of the world, say for example, if you look at India, they have separate laws for every religion. So it goes differently for a Hindu, differently for a Muslim, differently for a Christian, and differently for a Parsi. We have so many different types of laws in that country. Like that, if you look at a country like United Kingdom, each United Kingdom, of course, it's a federation. So each country in United Kingdom, technically, when you say, because England, Scotland, Northern Ireland, and Wales are different countries into the United Kingdom. So each country has its own separate system of inheritance. So even when a person comes and tells us, I'm from the UK, we ask him, okay, where in UK are you from? Are you from England or Scotland or Wales or Northern Ireland? So it all depends. I mean, if you look at United States of America, 50 states have their own separate sort of laws with regard to how it has to go. Personal laws are different. It's very regionalistic, very religious, and things like that.
So Dave, there's one more question added to that. If I do not do the will, how will the Sharia law be in that case?
That is what I had mentioned earlier, how it will go. It will go as per Sharia insist on a certain forced heirship to legal heirs. So if you don't have a document in place, if you don't have documents in place, it will go as per the table. So if the husband passes away, the wife gets 1/8, father gets 1/6, mother gets 1/6, and the children get the residue. Boys get double of what the girls get. And if the lady passes away, the wife passes away, her father and mother get 1/6 each, husband gets 1/4, and rest of it goes double to the boy and half to the girl. So that is how it works as a share. So if you don't have documents, this is how they will share it. We have one more question.
Yes. Do bank account get frozen if it's not a share account if one of the spouse deceases?
Yes. See, if it is not a joint account, it will not get frozen if one of them diseases. Only the deceased person's um, account will get frozen, not the other person. See, there is a lot of misconception here, because what happens is that many many people they think, if a wife is a homemaker, she cannot have a bank account. She can definitely have a bank account. There is nothing wrong in her having a bank account in this country. Only thing is, if you're not working, if you're not salaried, or if you're not an investor or whatever it is, you will not be getting a checking account. That is a current account. You will not get a checkbook and a current account, but you will still start a savings account. So nothing stops a resident in this country to start a bank account. You can have a bank account. It doesn't stop you.
There's one more question from the same client. If the parents get deceased and are not alive, how will the Sharia is applied for the kids?
Yes. What happens is that then the Sharia table comes into effect. The next level of inheritance come into the scene. Say, for example, if my son is a minor, and or say I have a son and daughter, for example, and if I pass away and my wife is survived, my wife will get still only 1/8, nothing else. She doesn't get anything more than that as per Sharia. But because my children are minor, what happens is that if I don't have my parents around, my brother and sisters, they get a share. Mainly my brother will get a share. And unfortunately, if I have only daughters and I don't have son, they will become the major shareholders. My brothers and sisters will become the major shareholders in the whole assets if I don't have my parents. That is, that 1/6 will go to them. And because there is no male heir, my brother will become the major shareholder because I don't have any son. But then the complication is that if I don't have a brother, because nowadays families are pretty small, and personally, if you look at it practically, with me, I have only one sister. So what happens? The major shareholder will become my cousin brother, whom I see maybe once in 5 years or 10 years in some wedding or some funeral. So that person will become the major shareholder. So that is the complication of the whole table. But then it's your choice whether you want to do a documentation and distribute your assets as you like, or you want the court to allow it to apply the Sharia and
Yeah,
distribute.
absolutely. I think
Uh,
what you have
yeah,
pointed out is very good point. Like, it will go to some, it can go to even cousins or, far relatives who are
yeah,
not even, we are not meeting them also.
yeah. that is what it is. I mean, like, it's a practical side of things. And people always think, they always, when clients come to us, they always get worried about what happens in the UAE. We have Sharia and all those things. But what they don't think is what happens back home. See, what you have to understand is, like, for example, if you're from India, do we have any other nationalities here,
Yes,
Asfar?
yes. We have other
What
nationalities.
nationalities do we have?
We have nationalities, Ingrid is from Honduras.
Okay, fine. Excellent. So it's all very regionalistic. The laws are very regionalistic, and it has to go as per that. And Honduras, of course, again, a civil law country because of the European influence there. So what happens is that the laws will become very peculiar, and the shares will go as per the local laws or the religious laws or the regionalistic law. So people always presume, like, say I'm an Indian, and if I pass away, everything will go to my wife. No, it doesn't. See, even if you're a Hindu, the shareholding goes to 1/4 to your wife, 1/4 to your mother. So there itself is a daughter-in-law, mother-in-law issue crops up. And then the children, if you have 2 children, they get 1/4 each equally. But then the issue is when you have minor children, it gets very sticky, because when the minor assets are held, the court starts holding the assets for some time. Even one of the cases which we are dealing now with Urvashi is also dealing with is it's a case of a situation in tsunami. It's a case of a situation in tsunami, where what happened was this family went for a holiday to Sri Lanka from UAE, and the father and mother and one child got washed away in tsunami. Only one boy escaped because he got wedged into a tree. Now, this boy was a minor, and his uncle, his father's brother, took all the trouble and finally went through a lot of documentation, a lot of trouble, and finally took this boy to US, adopted him legally. And of course, he was kind enough. You know, the father had a very nice brother who adopted him and took him to the USA. Now, what happened? All the money which was held in UAE has been held up because this boy was a minor. So the court has frozen everything because it's a minor. And then the uncle also, of course, he had money, so he brought up the child. He didn't look for the money which was left by the parents. So now the boy has become 21 years old, and they have got back to us. When did the tsunami happen? It was in 2006. So after 14 years, they have come to us to sort out and collect the money from the banks. Now, the complication is the money is not with the banks. The money has gone into a suspense account with the Central Bank of UAE. So the process is going to be longer because the claim has not been filed at that time. Process is going to be longer. But then we are going to go through that process and get the money for this young man, you know, who's now 21 plus. So, you know, now this is a 14-year story. I earlier told you 9 years, but anyway, that's a different issue. But this is a 14-year-old story. So, so this is what happens. You know, like at the same time, if this father or mother would have had a proper will document in place, it would have been so easy for the guardianship of this uncle to take over the child when the rest of the family is not there, when both parents are not there, and he could have claimed this money also. So easily as an executor of a will document, he could have claimed this money and used it for the benefit of the child.
Okay. And for the attendees, just one more thing. What would be the average cost of a will?
It all depends on your nationality and your where you want to do it. Whether you want to do it in Abu Dhabi, Dubai, or DIFC, the cost goes on differing. But a ballpark figure is somewhere between and the legal fees and the translation fees and all those things. But the ballpark figure will be somewhere around between, say, about 7,000 to 20,000 dirhams of where you want to do it.
Okay.
Or how you want to do it. It'll range between 7,000 odd dirhams to somewhere around 20,000 dirhams.
Perfect.
So it all depends on the leader.
I think we are done with question and answer. No more questions are there. Once again, thank you, Devanand, for this session. It has been actually been happy to be on. You was with us, and I appreciate your time also. And thank you everybody for attending this webinar. I hope you have gained some knowledge on the why it is required, why it is important to have an inheritance planning.
Thank you so much. Thank you so much.
Stay healthy, everybody. See you.
Thank you, everyone. Bye-bye.
Bye.